morning, everybody, and thank you to the members of the Human Rights Commission for the invitation to speak today. Good morning to Mrs. Jami, the chief guest, and all others present here today. So, I think I was asked to speak about domestic violence laws, but I'm going to confine myself to the Prevention of Domestic Violence Act of 2005. On the one hand, I think all of you know the Act is quite broad and applies to family violence in general, but since we're celebrating Women's Day today, I'm going to talk about the Act in relation to intimate partner violence. It is really a timely moment to talk about the Act because this year marks 20 years since the Act was passed. Some of you will remember the Act was passed unanimously in Parliament in 2005 after many years of activism by women's rights organizations. And at the time it was celebrated as a milestone in our engagement with the law and legal reform in Sri Lanka. So in the time that I have, I want to very briefly reflect on two things. One, the significance of the law, and two, the limitations of this law. But first, what does the PDVA really do? What it does is it allows any person who suffers violence or is about to suffer violence, likely to suffer violence, apply for a protection order at a magistrate's court. And once the application under the PDVA is received, the magistrate court is empowered to issue what is known as the interim protection order for 14 days, and then later convert the interim protection order into a protection order which is valid for 12 months based on evidence which is presented in the court. And this evidence can include things like police records, medical records, and testimony from witnesses. Protection orders themselves can take a number of different forms. They can bar a perpetrator from having any kind of contact with the applicant. It can also bar the perpetrator from entering the family home. Now, the Act does not create a new offense of domestic violence. Rather, it defines domestic violence firstly as acts of physical violence, which constitute those offenses already recognized in the penal code, and secondly, it recognizes emotional abuse, defined as a pattern of cruel, inhuman, degrading, or humiliating conduct of a serious nature. In addition to the aggrieved person, the Act recognizes that a police officer may apply for a protection order on behalf of someone. And the courts have also allowed women's organizations to file for protection orders on behalf of a victim survivor of violence, even though the Act does not specifically refer to women's organizations or mention them. So why is this law significant? First, I think it is symbolically significant because it renders what has long been considered a private family matter a matter of public concern. It sends a message to society in general and perpetrators of domestic violence in particular that this kind of violence is unacceptable. In doing so, it challenges popular narratives that trivialize, normalize, and legitimize intimate partner violence. Secondly, it is materially significant because it authorizes a court to intervene and protect women who are facing abuse and violence at home. Prior to its enactment, women in Sri Lanka didn't really have a legal remedy for intimate partner violence. They could make a police complaint, and often women did, but the police rarely took these complaints seriously. And women themselves didn't often want to file criminal charges against their husbands. So the advantage of a protection order under the PDVA is that it gives a civil remedy. In invoking the law, you're asking for protection without invoking criminal law. The evidentiary burden on the complainant is far less than in criminal proceedings, and therefore it has the potential to ensure immediate relief it is also less time consuming. But as we know, laws rarely work as they're supposed to, and this is also the case with the PDBA. There are many implementation problems, and I think Lisa and Sarah probably, and others in the room are probably more aware of these. But even 20 years later, many police officers, judges, and lawyers really don't know about this law. And even when they do know, they may actively undermine the law because of patriarchal attitudes. The Act also does not, and some of this has already been said by Mrs. Jamil, the Act does not also provide for proper monitoring of protection orders, which means that they can be easily violated. And there are some terrifying stories about women being subjected to even more violence, in some instances fatal, as a consequence of filing for protection order. This is also because, as Mrs. Jamil already mentioned, there are insufficient shelter facilities for women who apply for protection orders under this Act. So because of all these implementation problems, there is now a consensus that this law has to be reformed. At the recent CEDAW review, the government in fact stated that it is planning to replace the current PDBA with a whole new Act. Now we do hope that there will be some consultation before the old PDBA is replaced with a new law. It is important to strengthen this law because increasing numbers of women are filing cases under this law. According to police statistics, the police filed around 1,500 cases under the law island-wide in 2023. Women in Need, one of the leading women's organizations providing support services for women, also filed around 200 cases through their several offices around the country. In addition, the Legal Aid Commission also files cases, although I don't have the statistics. But what we don't actually know is how many protection orders are issued once an application is filed under this law, and how effective these protection orders are. However, it is also important to acknowledge that these numbers of people filing cases under the PDBA represent only a very small percentage of survivors of intimate partner violence. According to the last demographic and health survey conducted in 2016, 16% of the women respondents between 15 and 49 years reported intimate partner violence, but it may be much higher. I think you mentioned that it's almost 30%, right? Only 28 of these women sought any kind of help to escape domestic violence, and only 18% of those women had ever gone to the police, and only 0.4% of women had gone to a women's organization. So we can surmise from these statistics that only a very small fraction of women, probably under 1%, are using this law. Now there is a reason for this, and remember this is 20 years after this Act was enacted. Even though protection orders are a civil remedy, the fact that you have to go to a magistrate court to get it makes this a very contentious process. A good wife in Sri Lanka, we all know, is one who is expected to endure the violence in silence and not talk about it in public, much less take her husband to court. It is not entirely clear how many marriages actually survive once a woman files a case under this law. So it's a very stark choice for women, I think. Do you suffer violence in silence, or do you put your marriage in jeopardy by making a complaint under the PDBA? Many women, I think, will prefer to suffer in silence to protect their marriages. Srimati Sivamohan, in an article she wrote in 2016, asked, why would a woman stay in a marriage that is full of violence? Answering her own question, she says she wants a husband. She wants to bear children, these fulfill her needs. I I think we have to take Sumati's work seriously. As feminists, as activists, and also policymakers and implementers, we have to contend with this reality. And that means seriously reflecting on implementation gaps in a holistic way, but also to ask how can we slowly and patiently build up a will to social justice for all without discounting women's desires and wants. State, independent institutions, lawyers, civil society, feminist activists, we all have a responsibility to try to address this, looking at